Now we get a chance to look at a remedies problem that touches on torts and even a little bit on civil procedure. Take a look at the call of the question. What evidence must NAS produce to make a prima facie showing on each of its claims? What defenses might Halfway reasonably assert, and how should the court rule on each of NAS's claims? Discuss. Well, I admit this doesn't really give us anything to organize. We know who the parties are. We know that it is something called NAS versus something called Halfway. We know that there are going to be claims that we will either be told or will have to identify. We'll have to consider defenses, and ultimately remedies appear to be, at least in the background here, because no party will bring a theory of liability without having a prayer for relief. Go to the top of the question, and we see early on that this is a complicated, intricate set of issues. Look at paragraph 1, and here we are introduced to Halfway. That's our defendant. They're a non-profit corporation that's licensed by the state and that tries to help rehabilitate former convicts. We see that it buys a parcel in a neighborhood that is zoned for multiple family use, but almost the rest of the whole neighborhood is single-family residences. In paragraph 2, we learn about the success of Halfway. We notice that they are trying to rehabilitate sex and drug convicts. We see that these convicts have a high recidivism rate, but we see that Halfway is successful. They do a good job with their charges. They reduce the recidivism rate. And we see that a key aspect of their success is the fact that they are helping to mainstream their clients in a nice residential setting. Then in paragraph 3, we find out about NAS. They are a group of community members who don't like this halfway house, and we see that they're concerned that the halfway house will damage their property values. Look toward the end of this paragraph, and we see that one of the members of this group was actually assaulted. But look carefully, and we'll see that member of the community was assaulted not by an inmate, but by a construction worker during the time that Halfway was getting the house ready to use. So now we pause for a moment, and we have to wonder to ourselves, what theory of liability could NAS bring at all? And then we see in the next to the last paragraph that 20 years ago, an injunction had issued and had been recorded in the chain of title forbidding the use of the property as a residence by unmarried people living together. And we see why that injunction had issued. A bunch of rowdy college kids had had a loud set of parties going on in that parcel 20 years ago. Well, that is an interesting issue, and we're going to have to look at it with great care. This is one of the issues that makes this a potentially quite aggravating fact pattern. Now, in the very last paragraph, we find out about the actual complaint. NAS has sued on behalf of its members, and what NAS wants is an injunction in tort prohibiting Halfway from operating a halfway house on this parcel. And the reason, the justification, is there's a public and private nuisance. Now we know what the plaintiff's theories of liability are: public and private nuisance. And the plaintiffs also are seeking a declaratory judgment that the 20-year-old injunction is an in rem injunction that prevents Halfway from operating a halfway house there. And then we get the call of the question again. So we can pause for a moment, consider the material that was given us in the last call of the question, and one thing that I think we can realize pretty quickly is you don't have to be a defense lawyer to realize that these plaintiffs are on pretty shaky ground. They don't seem to have a very good theory of liability, and their prayers for relief seem to be out of proportion to the facts that are alleged. So take a look at the outline of issues that I've presented, and let's see how we could frame a thoughtful, careful, and correct answer to the issues presented. It seems to me that a threshold issue that we need to discuss here is association standing. That's really an issue from civil procedure, but it has cropped up here in this question because we're dealing with an association coming to court. And we don't grant an association standing automatically. We have to look at the facts and carefully consider a three-part test. So first we wonder, is this action relevant to the association's purpose? Answer, yes. The association's concerned about the neighborhood, property values, etc. An action against a halfway house operating in that neighborhood certainly would be relevant to the purpose of the organization. Would the individual members have standing? Well, that becomes somewhat more complicated. Certainly, the member that was injured by the assault would have standing, but this is a somewhat problematic issue here as well, because it is unclear whether or not this halfway house is really causing any harms. So certainly no individual participation would be involved. It seems to me that association standing is not guaranteed, but I think we can reasonably conclude that a court could well allow the action to proceed. So let's consider the real theories of liability, public and private nuisance. Well, in order for public nuisance to be litigated by private citizens, there's got to be a special injury suffered. And here, the only special injury that can be pointed to is the injury of a NAS member at the construction site or during the time of the construction work on the halfway house. Is that a special injury that will justify litigating a public nuisance? I think it's a fairly dubious call, but I guess we can conclude that very tangentially, very minimally, a claim for public nuisance perhaps has been stated. Has the public safety, health, or property values been implied here? I suppose they have, but you'll notice we don't have any specific facts in this pattern dealing with any impact on housing values, either in this neighborhood or in any of the earlier neighborhoods that Halfway has been involved with. So I am dubious in concluding that a public nuisance has been established. And personally, I would find that the plaintiffs have failed to state a claim here. Let's move on to private nuisance. Has there been any intentional interference? Again, I think the plaintiffs are on pretty thin ice even at this point. I don't think they can show a real harm. But let's assume for a moment that their concerns about property values are good enough to establish a private nuisance. Certainly, the plaintiffs are genuinely upset. Then we have to engage in a balancing test. Are the concerns of the community, how do they balance against the benefits that are brought to the society by a successful halfway house? We know the halfway houses are successful. We know that these clients, these ex-defendants, are likely recidivists. Certainly society, including this neighborhood, benefits from rehabilitating sex and drug criminal convicts. So even with regard to the balancing test, I just don't know that the plaintiffs have stated a theory of liability, and I don't think you need to be a defense lawyer like me to be able to examine these facts and sort of scratch your head a little bit about why the plaintiffs are so upset. It seems to me that they are worried about a future that hasn't come and that doesn't seem that likely to come. So I would ultimately conclude that the plaintiffs haven't even established a theory of liability. I don't like their public or their private nuisance claims, and I don't think the facts alleged here are good enough to state a claim. But let's assume for a moment that they have, and let's go on to consider an injunctive remedy. That's what they really want. The plaintiffs don't want this halfway house in their neighborhood. Are legal remedies adequate? Well, real estate is unique. A neighborhood certainly is a unique combination of real property interests. Giving these people money probably is not going to make them feel as if they've been made whole. Are property rights at stake? Again, the answer here is clearly yes, but I personally don't see how the defendant's conduct has hurt the plaintiffs in a quantifiable way. Would it be feasible for a court to issue the injunction the plaintiffs seek? Yes, no problem there. Now, we turn to balancing the hardships, and if we assume for a moment that the plaintiffs had a difficult time establishing the balance of hardships at their theory of liability stage, now we come to their prayer for relief stage, and I'm just not inclined to find the balance favors the plaintiffs. Even if you have examined the facts and concluded that the plaintiffs ultimately do state a theory of liability, I don't think the facts alleged entitle them to equitable remedies. So my conclusion is, even if the plaintiffs have established a valid theory of liability, I will limit their recovery to money damages because the balance of the hardships at the injunction stage favors the defendants. So my conclusion overall is these plaintiffs lose across the board. Maybe I'll grant them standing to sue, but at that point, that's the only thing they're going to win from me. They lose at the theory of liability stage, and in my court, they lose at the prayer for relief. So now we turn to what I personally think is the most interesting of the plaintiffs' claims, which is that even if we set aside their nuisance claim, focus on the declaratory judgment issue and the in rem injunction theory. Here the plaintiffs have got a pretty solid leg to stand on. Now, ultimately, I'm going to find for the defense here as well, because clearly this injunction was targeted at a group of rowdy college kids. And it's apparent that one thing we can say about a halfway house for sex and drug offenders is it is not a party house. The whole idea here is to mainstream these ex-cons and to provide them with guidance and counseling. We're not going to be having any parties of any kind in this halfway house, certainly not the kind of loud, and I might add with fond memories, fun parties that likely took place on this parcel 20 years ago. So the in rem injunction theory is, on its face, a valid theory. A more careful examination of the facts suggests that the defense is likely to prevail here as well. So although the defendants are having to answer, I think, a more substantive claim here with regard to the declaratory judgment, the result, again, is on the side of the defense. Ultimately, the plaintiffs here really don't have a very good theory of liability. Their prayer for relief is one that I think most reasonable people would not be hugely sympathetic to.